Next up is going to be Unit 47. We're going to talk about checklists for sellers. These can be found on Transaction Desk under the Arizona Association of Realtor forms in Transaction Desk. These are AAR forms. So the seller, the documents that they need to sign and understand and be disclosed. The number one thing as an agent, you need to provide your client is agency disclosure, documentation of the agency relationship and representation. So you're getting your client to sign on that the agent, like who are you going to be representing as you and who's the client. Next is the listing agreement. This is a contract between the seller and the real estate agent. So the listing agreement just outlines purchase price, things of that nature. Purchase agreement, right? Once you get your listing offer accepted, then you can go on with the purchase agreement. Once an offer has sent an offer, and then you've accepted it. Agreement signed by the seller to accept the buyer's offer. Next is wire fraud advisory. It's information about warnings about wire fraud. HOA addendum, if applicable. Disclosure regarding homeowners association rules. The SPUDS, seller property disclosure statement. Seller property disclosure statement. So that's the SPUDS. It's completed and signed disclosure regarding property condition. So this, literally what it says, can the agent fill this out? No, the seller must fill out the seller property disclosure statement. MLS input sheet. This is details for entering the listing into the MLS system. The MLS printout, once it's active, print it out, listed from the MLS. You need the claims history clue report, so you're going to ask your seller to provide you with a history report. Report on insurance claim history ordered by the seller from the insurance company. The market condition advisory disclosure report, such as disclosure or report on current real estate market conditions. Lead-based paint disclosure. This is only required if the property was built before 1978. Preliminary title report, acknowledged by the seller to clear any title issues. Home inspection response, if applicable. Response to the buyer's inspection, including any repairs agreed upon. Bill of sale for personal property. This is going to be if your seller wants to sell a couch or a boat or anything personal that's not coming with the real estate to the buyer. So that happens on a separate bill of sale for personal property. That does not come with the real estate contracts. It's a separate bill of sale. It's an agreement transferring personal property not included in the property deed. Payoff statement for existing mortgage. This is a document showing the remaining mortgage balance to be paid off. HOA documents. If there's any HOA documents, you need to provide the AAR contract. Closing statement for the HUD-1 form. This goes over final financial breakdown signed by the seller at closing. Sold change form. Document to update the property status as sold. So once you sell the property, what do you need? A sold change form, right? So that's a document to update the property's status as it's sold. Consent to limited agency, if needed. Agreement if limited representation is applicable. Cure notice. If you're dealing with an agent and they're not on the up and up with everything that you've done, send them a cure notice, and it will get done. Right? It will go up to the broker. It's a document issued if a party needs to correct an issue. That's the cure notice. The BINSR, buyer inspection notice seller response. Buyer inspection notice seller response. So the BINSR is when buyer does their inspection and then they want something done. So it's a document for inspection results and negotiation. So they'll typically a buyer will use that against the seller to repair things, fix things, ask for some money off the property, and then the seller can respond typically with two options saying, no, we're not going to fix anything, or yeah, we'll fix some things, or yeah, we'll give you a credit, right? Kind of like three options. Inspection reports, detailed reports from the property, addendums, any additional contract documents or clauses. You can add an addendum. Additional clauses addendum if needed. Final walkthrough. So this is a verification of property condition before closing. Counter offer, if you need it. You might not always need a counter offer, but it's going to be a document detailing the counter offer terms. Home warranty information, if applicable. Um, Not all of these documents are needed, but this is a list of the documents you're more than likely going to need. Information on any included home warranty, wastewater treatment disclosure. You may or may not need it. Information on wastewater systems, commission instructions, document signed by the broker for the commission details, earnest money receipt, right? It's a receipt for earnest money deposited, title commitment, commitment for title insurance, often signed at closing. You have the final HUD, right? Final HUD is a statement showing pending or a closed transaction, usually is given by the title company. Warranty deed, it's a signed deed to officially transfer ownership to the buyer. Affidavit of title, it's going to be a signed statement confirming no additional claims on the property. IRS Form 1099-S, it's a report of sale to the IRS for tax purposes. Signed, acknowledged. Again, usually one of these documents is usually from the title company. Solar documentation, if you need it. Documents related to solar panel installation, ownership, lease, or power purchase agreements, including warranties, maintenance agreements, and transfer of ownership if solar panels are included in the sale. Pool disclosure, if needed, right? Disclosure about the condition, maintenance, and any warranties or service agreements related to the pool and pool equipment. So this outline is going to give you some guidance in what contracts are needed for the seller. There may be other forms needed, depending on the transaction. If you have any questions, then see your broker. This is another list of residential documents, and here's listing required documents as well. Here's going to be another list. This one's typically on new construction, so building purchase contracts and all other addendums with buyer and authorized building signatures. The copy of earnest money, copy of receipt of the public report signed by the buyer for new construction buildings, real estate agency disclosure and election. Right? Who's your realtor? Do you have a document signed with your realtor? That's real estate agency disclosure. Copy of receipt of the buyer advisory if representing the buyer. Vacant land sales, required documents. Vacant land lot purchase contract and all addendums. Real estate agency disclosure and election. SPUDs, seller property disclosure statement. Vacant land lot seller property disclosure statement. The BINSR, the buyer inspection notice seller response. Vacant land buyer's inspection. Notice and seller's response, copy of MLS printouts, copy of earnest money, additional required documents. So when you represent both the buyer and the seller in any transaction, you're going to need what? A consent to limited dual representation. So again, it's in the AAR, Arizona Association of Realtors library, under transaction desk. Commercial sales, if you're going to do any commercial sales, commercial purchase contract, and all addendums. Again, you want the real estate agency disclosure and election. You want the SPUDs, seller property disclosure statement. So commercial seller property disclosure statement, copy of the MLS printout, copy of earnest money receipt from the title company, residential rentals, required documents, rental agreements and all addendums. So if you're selling your own property, when you are the seller or you have some ownership interest, you're going to need what? Owner agent addendum. So it's going to be just an addendum, an additional document claiming that you are the owner agent. It's an owner agent addendum to purchase contract, right? You can find addendums in the Arizona Association of Realtors, and there's a landlord agent addendum. So those are if you're a landlord, you can get a landlord agent addendum, right? It's an additional document if you need it. All right, so next up, we're going to cover real estate agency disclosure and election contract. So this is the contract from Transaction Desk in Arizona Association of Realtors. So this is the real estate agency disclosure and election document. So this document is not an employment agreement. It's page 1 of 2. This agency disclosure and election is 2 pages. So you add your firm name, the broker's company name, and it's acting through who's the agent. You put their licensee name. This is just an example. Hereby makes the following disclosure. Here's the disclosure. The disclosure is before a seller or landlord, hereinafter referred to as seller, or a buyer or tenant, hereinafter referred to as buyer, enters into a discussion with a real estate broker or license affiliated with the broker. The seller and the buyer should understand what type of agency relationship or representation they will have with the broker in the transaction. So number 1, buyer's broker. The broker often, then the seller's broker can agree with the buyer to act as the broker for the buyer. In these situations, the buyer's broker is not representing the seller, even if the buyer's broker is receiving compensation for services rendered, either in full or in part, from the seller or through the seller's broker. A buyer's broker has the fiduciary duties of loyalty, obedience, disclosure, confidentiality, and accounting in dealings with the buyer. B, other potential buyers represented by brokers may consider, make offers on, or acquire an interest in the same or similar properties as buyer is seeking. Seller's broker. A broker under a listing agreement with the seller acts as the broker for the seller only. A seller's broker has the fiduciary duties of loyalty, obedience, disclosure, confidentiality, and accounting in dealings with the seller. So fiduciary duty, we typically use an acronym called CARLOAD. Care, so CARLOAD, care, accountability, right? There's accounting, obedience, obey. We must obey. It even says it in our disclosure. We are to obey. So loyalty, CARLOAD, C, caring, accounting, reliability, loyalty, obedience, and disclosure, right? So obedience, disclosure, confidentiality, and accounting and dealings with the seller. So that's fiduciary duties. That's CARLOAD, right? CARLOAD is those types of things you would do for a client. Other potential sellers represented by a broker may list properties that are similar to the property that seller is selling. The broker representing both seller and the buyer, call this limited representation broker, is where a broker, either acting directly or through one or more licensees within the same brokerage firm, can legally represent both the seller and the buyer in a transaction, but only with the knowledge and informed consent of both the seller and the buyer. In these situations, the broker, acting through its licensees, represent both the buyer and the seller, with limitation of the duties owed to the buyer and the seller. The broker will not, without written authorization, disclose to other parties that the seller will accept a price or terms other than stated in the listing, or that the buyer will accept a price or terms than that offered. So basically, it's saying we're not going to accept anything other than what's offered in the contract. There will be no conflicts in the duties of loyalty, obedience, disclosure, and confidentiality. Disclosure of confidential information may be made only with written authorization. Regardless of who the broker represents in the transaction, the broker shall exercise reasonable skill and care in the performance of the broker's duties and shall be truthful and honest to both the buyer and seller, and shall disclose all known facts. Typically, it's material facts, right? Which materially and adversely affect the consideration to be paid by any party. Pursuant to ARS 32-2156, even states law, sellers, leaseors, and brokers are not obligated to disclose that a property is or has been 1. The site of a natural death, suicide, homicide, or any crime classified as a felony. 2. So in the agency disclosure, it straight up tells you that, if murder was occurred or homicide or something like that, agents do not need to disclose any of that. Only material facts. A big hole in a wall, something like that. Owner occupied by a person exposed to HIV or diagnosed as having AIDS or any other disease not known to be transmitted through common occupancy of real estate, or located in the vicinity of a sex offender. Sellers or sellers' representatives may not treat the existence, terms, or conditions of offers as confidential unless there is a confidentiality agreement between the parties. So if there's a sex offender in the neighborhood, does the agent have to tell you? No. If there was suicide, homicide, agent will not tell you. They don't have to tell you. They can. The duties of the broker in a real estate transaction do not relieve the seller or the buyer from the responsibility to protect their own interests. The seller and the buyer should carefully read all agreements to ensure that the document adequately expresses their understanding of the transaction. So again, the duties of the broker in a real estate transaction do not relieve the seller or the buyer from the responsibility to protect their own interests. The seller and the buyer should carefully read all agreements to ensure that the documents adequately express their understanding of the transaction. So you need buyer and seller. Just because you're using a broker doesn't mean you don't need to do any work. You still need to read and understand everything you're signing. Second page, real estate agency disclosure and election. Agency election does not establish broker compensation. So you're just you're electing your agent in this contract. Compensation paid by a buyer or seller to their broker is not set by law. It is always fully negotiable, and the amount chosen shall be documented in a separate written employment agreement after discussion with their broker. Should a seller also choose to offer compensation to a buyer's broker, the offered amount is also not set by law. It is fully negotiable and agreed upon after discussion with seller's broker. So here the buyer signs under election, buyer or seller initials required. So this is the first document you give to a buyer or seller. Their agency of selection. Basically, they're saying they're going to work with the agent. This is the first document you give to them. Buyer or tenant election. So if you're working with a buyer, you check one of these boxes. If you're working with a seller, you check one of those boxes. There's 3 boxes to check. So complete this section only if you are the buyer. The undersigned elects to have the broker check any that apply. So represent the buyer as buyer's broker. Are you going to represent the seller as seller's broker? Buyer shows buyer's property listed with the broker's firm, and buyer agrees that broker shall act as agent for both buyer and seller, provided that the seller consents to limited representation. In the event of a purchase, buyers and sellers' informed consent should be acknowledged in a separate writing other than the purchase contract. So if you're working with the buyer, check the first box. Buyer, and then this represents that you're the working with the buyer's broker. If you're working with the seller, have them check the first and third box. If you're working with the buyer, have them check the first and third box. Represent the buyer as buyer's, or sorry, the second and third, and the buyer is first and third. So seller represents seller, seller's broker. You're going to show the seller's property to buyers represented by broker's firm, and seller agrees that broker shall act as agent for both seller and buyer, provided that buyer consents to the limited representation. In the event of a purchase, buyers and sellers' informed consent should be acknowledged in a separate writing other than the purchase contract. Line 60, the undersigned. So if you're working with the buyer, have them check that box. With the seller, have them check that box. And then you'll pretty much have those boxes checked in the MLS in transaction desk when you send it out, email it to your clients. And then you print the name and sign there. We'll talk about real estate agency disclosure and election. So whenever you're going to do a deal with an agent or a broker, you need to disclose and elect them. So this document is not an employment agreement. The pre-printed portion of this form has been drafted by the Arizona Association of Realtors, AAR. Any change in the pre-printed language of this form must be made in a prominent manner. No representations are made as to the legal validity, adequacy, and or effects of any provision, including tax consequences thereof. If you desire legal, tax, or other professional advice, please consult your attorney, tax advisor, or professional consultant. So you'll put the firm name, you'll line 2, acting through a licensee name. Line 3, hereby makes the following disclosure. Here's the disclosure. Before a seller or landlord, hereinafter referred to as seller, or a buyer or tenant, hereinafter referred to as buyer, enters into a discussion with the real estate broker or licensee affiliated with the broker, the seller and the buyer should understand what type of agency relationship or representation they have with the broker in the transaction. So line 7, line 1, buyer's broker. A broker other than the seller's broker can agree with the buyer to act as the broker for the buyer. In these situations, the buyer's broker is not representing the seller, even if the buyer's broker is receiving compensation for services rendered, either in full or in part, from the seller or through the seller's broker. A buyer's broker has the fiduciary duties of loyalty, obedience, disclosure, confidentiality, and accounting in dealings with the buyer. So we call it carload, right? Care, obedience, disclosure, confidentiality, and accounting. Other potential buyers represented by broker may consider, make offers on, or acquire an interest in the same or similar properties as confidentiality and accounting in dealings with the seller. Other potential sellers represented by broker may list properties that are similar to the property that seller is selling. Broker representing both the seller and buyer. Limited representation broker. A broker either acting directly or through one or more licensees within the same brokerage firm can legally represent both the seller and the buyer in a transaction, but only with the knowledge and informed consent of both the seller and the buyer. In these situations, the broker, acting through its licensee, represent both the buyer and the seller, with limitations of the duties owed to the buyer and the seller. A. The broker will not, without written authorization, disclose to the other party that the seller will accept a price or terms other than stated in the listing, or that the buyer will accept a price or terms other than offered. So if you accept two parties, right, and one is selling it and they say we want 400,000, and your buyer says, what's the lowest he can go? Will he go 390? And the agent says, yeah, we can go 390. Then you just broken your fiduciary duty. You cannot tell your buyer, all right, so let's submit an offer for 390. Okay, you submit an offer, and then the seller says, how did they know 390? Right? It's because you told them. You're not supposed to do that. You're not allowed to do that. Don't tell them the bottom number. If the listing is 400, hey, make your best offer for 400K. Right? Make your best offer. Right? What's the minimum your seller's allowed to take? We said in the price 400K. We want 400K. If you submit less than 400K, I mean, the seller will consider it, right? We'll see how it goes. Okay. Regardless of who the broker represents in the transaction, the broker shall not exercise reasonable skill and care in the performance of the broker's duties, and shall be truthful and honest to both the buyer and seller, and shall disclose all known facts which materially and adversely affect the consideration to be paid by any party, pursuant to ARS 32-2156. Sellers, lessors, and brokers are not obligated to disclose that a property is or has been 1. The site of natural death, suicide, homicide, or any crime classified as a felony. 2. Owned or occupied by a person exposed to HIV or diagnosed as having AIDS or any other disease not known to be transmitted through common occupancy of real estate. Or 3. Located in the vicinity of a sex offender. Sellers or sellers' representatives may not treat the existing terms or conditions of offers as confidential unless there is a confidentiality agreement between the parties. The duties of the broker in a real estate transaction do not relieve the seller or the buyer from the responsibility to protect their own interests. The seller and the buyer should carefully read all agreements to ensure that the documents adequately express their understanding of the transaction. So, I mean, this goes again, protect yourself at all times. You are going to use a broker or a realtor to help you in the transaction, but you still need to know and read all the documents and understand all the documents. Be of sound mind. Election. Agency election does not establish broker compensation. Compensation paid by a buyer or seller to their broker is not set by law, is always fully negotiable, and the amount chosen shall be documented in a separate written employment agreement after discussion with their broker. Should a seller also choose to offer compensation to a buyer's broker, The offered amount is also not set by law, is fully negotiable, and agreed upon after discussion with the seller's broker. So buyer seller initials required here. So this is the latest and greatest document. This was updated November 2024. Buyer or tenant election, you'll check there. If you're the buyer, seller, we'll check there. If you're the seller, right? The undersigned buyer or seller acknowledges that this document is a disclosure of duties. So, what is this document really all about? It's just disclosing the duties of your realtor or your broker. So, this is the real estate agency disclosure and election, right? Who's representing you, right? But you're not putting on here the compensation. This document is just what are the duties, what is your realtor owe you? What are the services that you're getting into? In contract. So here, exclusive right to sale or rent. So you'll put in your parties, the property, the listing price and terms. Compensation, here's an example. The big thing here is a sale, 6% of the purchase price, or buyer broker 3% to the buyer broker. It's usually 3% to the buyer broker, 3% to the listing broker, to make a total of the 6% you see there. Put in the agency, have your owner initial each page, owner's obligation, remedies, in case you need to fix something. You can add additional terms, assignment. The days are all going to be deemed as calendar days unless otherwise provided. So Monday through Sunday. So they're always calendar days. So you would count Monday, Tuesday, Wednesday, Thursday, Friday, Saturday, Sunday. That's going to be 7 days. It's a calendar day, not a business day. Business days, Saturday, Sunday doesn't count. So that's why we use calendar days. And then have your listing broker, owner sign. Next up is the wire fraud advisory. So here you need to protect yourself at all times. Make sure you do not trust emails containing wire instructions. Trust your source. HOA. So here you want to put the seller information, associates governing the premises, add in your HOA, the management company, the amount of dues, other, any fees payable upon close of escrow. You want to add in your transfer fees, the capital improvement fees, and sometimes you can get this from the previous sold in the same community. It's going to be the same numbers. Additional obligations and intended for swimming. The SPUDS, the Seller Property Disclosure Statement, SPDS. So when in doubt, disclose. Arizona law requires the seller to disclose material, important facts about the property, even if you are not asked by the buyer or real estate agent. These disclosure obligations remain even if you and the buyer agree that no seller's property disclosure will be provided. So even if you think you don't need to sign the seller property disclosure statement, you still do, right? The seller should list everything wrong and everything they know, material facts about the property. That all goes into the SPUDS. The SPUDS is designed to assist you, the seller, in making these legally required disclosures and to avoid inadvertent non-disclosures of material facts. If the buyer asks you about and inspect of the property, you have a duty to disclose the information, even if you do not consider the information material. You also have a legal duty to disclose facts when disclosure is necessary to prevent a previous statement from being misleading or misrepresented. If you do not make the legal required disclosures, you may be subject to civil liability. So, message to the seller. Sellers are obligated by law to disclose all known material important facts about the property to the buyer, right? So the SPUDS is designed to assist you in making these disclosures. If you know something important about the property that is not addressed on the SPUDS, and that information to the form, prospective buyers may rely on the information you provide. Okay, so message to the buyer. Although sellers are obligated to disclose of no material important facts about the property, there are likely facts about the property that the sellers do not know. Therefore, it is important that you take an active role in obtaining information about the property. Instructions. So you fill out your property ownership, legal owners of property, what's the property address. Notice the seller. Arizona law imposes certain requirements on the sale or lease of subdivided and unsubdivided land or lots. If a sole if a sale involves six or more parcels, lots, or a fractional interest being sold, certain requirements are imposed on the seller for a subdivision public report. Information may be obtained by contacting the Arizona Department of Real Estate, ARS 32-2101, 56 and 57. So notice to the buyer, if the property is in a subdivision public report, which contains a variety of information about the subdivision at the time the subdivision was approved, may be available by contacting the Arizona Department of Real Estate or the home builder. The public report information may be outdated, so visit azre.gov. All right, so you're going to list yes or no for all these questions. Building and safety information, plumbing, swimming pool, electrical, miscellaneous, all these information. You're going to list about utility services, sewer water treatment, environmental information, and other conditions and factors. You'll have your seller sign, buyer acknowledgement. So buyer acknowledges that the information contained herein is based only on the seller's actual knowledge and is not a warranty of any kind. Buyer acknowledges buyer's obligation to investigate any material important facts in regard to the property. Buyer is encouraged to obtain property inspections by professionals, independent third parties, and to consider obtaining a home warranty protection plan. So this is just a big disclosure from the seller on everything that they know about their property they're selling. Next up, market condition advisory. So real estate market is cyclical, right? It goes up and down. There's no way to know how much your house is without doing a comparable market analysis by a realtor. The financial market also changes, affecting the terms on which a lender will agree to loan money on real property. It's impossible to accurately predict what the real estate or financial market condition will be at any time. So here's a disclosure to letting the seller and the buyer know that the market is cyclical, it goes up and down. Mold disclosure. So you'll add the subject property address. Recently, substantial attention has been given to the possible health effects of mold in homes, apartments, and commercial buildings. So mold found inside such buildings is referred to as indoor mold and is categorized as being either toxic or non-toxic. Certain types of toxic indoor molds may cause health problems in some people while triggering only common allergic responses to others. In others, non-toxic indoor molds are ordinarily no more than a common nuisance. Okay, so you get your buyer to initial and sign. Counteroffer. So if you get an offer and you want to reject, you can do a counteroffer. So you'll put in your counteroffer. Here's an example. You'll put in on line 6, acceptance of the above offer and counteroffer is contingent upon agreement to the following. So here we put close of escrow to be on this date, seller to install new hot water heater. All of the terms and conditions remain the same. So this is just a counteroffer example. Okay. Then you could do a multiple counter offer. Say you get two offers at the same time. So this is how you really help out your seller. So you put everything in here. So this is multiple counter offer, and you're going to send it to both of your buyers at the same time. So seller is making one or more counter offer. So once you submit, don't give this back to the don't give the counter offer, give them the multiple counter offer. So now the buyer is on notice that hey, there's more people bidding on the same house. So one, we put in the purchase price to be $450,000. That was our selling price. Seller concessions to be 0%. Close of escrow to be February. Days of inspection to be 7. Transfer fees to be paid by the buyer. Capital improvement fees to be paid by the buyer. Seller declines to pay for a home warranty. The property is being sold in as-is condition. So now the buyer's on notice that the seller is not going to make any improvements. No repairs will be completed by the seller. Contract acceptance period to be February 2024. So now the buyer is going to get this, and we'll see which of the multiple offers gets accepted. So in this deal, we got the deal at the best price, the best conditions, best terms I got from my client, and my client was very happy. So on the multiple counter offer, the buyer is going to respond here. Buyer acceptance, seller response, seller final acceptance. Next up, we'll go over the solar addendum. If you have solar, you'll put the seller, who's the seller, the buyer, the subject property. Instructions, is it owned or is it leased? You'll check there. Solar system lease / loan. Okay, so you'll add more information here, additional terms and conditions. You'll add in your signatures. All right, next is the MLS input sheet. So here you'll have your MLS input sheet, and at the very bottom right, you're going to have your seller initial. So again, here's an example of your MLS input sheet. So go into the MLS where you're listing, and then you can do a save copy. It's page 1 of 6. Okay, so here you have your second page, have your seller initial each page, right? You're basically verifying all the information that the seller provided to you from the SPUDs, from the seller property disclosure statement. And then they'll sign the last page. Printout. This is done this is found on the transaction desk. It was developed by Arizona Association of Realtors that created the AR form. So here is an example of the MLS printout. So what you're going to see here is the agent full detail report. It's not for distribution, internal use only. MLS number, it's going to be the top left. The dwelling type is residential, single family residence. Status is active. The list price is going to be listed. Here's an example. You'll have your address, your legal description, directions. It basically gives all the details of your MLS printout when you have finished, when you have gotten all the documents signed and you're able to finally put it out on the MLS. So we'll have a property description. You'll list agent only remarks. You'll have who is the title or the escrow company it's listed with, and you'll go from there. Second page, we'll talk about the listing information, the terms. What kind of loan are you going to be getting on it? Is it a cash, conventional, FHA, VA? What types of loans is your listing able to accept? Um, what are your terms? The co-op fee, that's actually removed a while back. You'll have your interior features, your exterior features, and your comments. Next up is the claims history reports from the insurance company, right? Sometimes it's actually referred to as the clue report. So here's an example. This is by Bennett and Porter, Wealth Management Insurance. So here it says insured. It'll have a policy number. Obviously, it's been redacted. Risk location. Um, the above caption policy was first enacted with Economy Fire and Casualty Co. on this date to date. The following claim has been filed under policy number for the residents located here. So any losses, right here says no losses. If you have any questions, contact. There's the phone number. So here's an example of one. Here's a second letter of experience and claims history. So you need to call your insurance company when you're selling your house and get the past 5 years, just an insurance and history report detailing the last 5 years. And then here's another one called LexisNexis. It'll have a detailed outline of what was reported on the property. Next up is going to be lead-based paint, anything that happened before 1978. So again, you'll mark lead warning statement. You'll have the seller's disclosure. You'll have your seller fill out 1 and 2 records, seller's initial required. Have them initial there. Buyer's acknowledgement, agent's acknowledgement. Next up, we'll have a cure notice if issue correction is needed. So you're going to use the cure notice if your realtor, your cooperating broker is not cooperating, right? So you send out what's called a cure notice period. You put the contact date, buyer, seller, escrow company, the property address, pursuant to the remedies section of the contract. You'll put is it the buyer or the seller? What issues are you having? Non-compliance with the contract. Okay, so you want to list what's the issue, and if they don't respond to your cure notice within 3 business days, then they are in breach of contract. Wastewater treatment disclosure, if needed. So on-site wastewater treatment facility addendum. So you'll list the buyer, the seller, the property address, your assessor's number, the date. So on-site wastewater treatment facility, it's an addendum, it's an addition, right? So you might not need this. The following initial terms and conditions are hereby included as part of the contract between the buyer and the seller for the above referenced property premises. Okay, so you'll add in here 1 or more on-site wastewater treatment facility, conventional septic, or alternative system. The facility has been installed on the property premises. There's on Department of Environmental Quality ADQ rules, requires a pre-transfer inspection by the seller. So facility inspection, seller shall have the facility inspected at seller's expenses, right? So you're going to list repair costs, buyer disapproval, notice of transfer filing fee. Then you'll have your buyer and seller both sign. Next up is the pool disclosure. So here, pool safety notice and receipt. You'll put the property by signing below. The buyer, tenants, seller, landlord of the property described above acknowledge receipt of the important notice about pool safety and the Arizona Department of Health Safety Policy residential pool safety notice in accordance with ARS 36-1681. So here's the Arizona Department of Health Services Office of Environmental Health residential pool safety notice. So main part here is as at a residence with a swimming pool where one or more children under 6 years of age live in the residence, you're going to need a pool enclosure. These are going to be all your requirements. If you don't have 6 or older, you don't need a pool barrier, right? Gate requirements are going to be listed here. Arizona Department of Health Service pool safety recommendation listed here. Contract, exclusive right to sell, rent. This form is on transaction desk. It's created by Arizona Association of Realtors, AAR forms. So in this exclusive right to sell, you're working with a seller and you are the listing agent. So one, you want to fill out the owner or the seller's information, fill out the owners, the broker, your name, put in the property, the premises. Owner agrees to sell or rent the property with all improvements, fixtures, and appurtenances therein or incidental thereto, plus the personal property described herein, collectively called the premises. All right, so premises where is the address of the subject property. Put in the assessor's number, the city, the county, legal description. So you'll put in what lot number it is, say lot 19, a replat. This is an example I have listed here. You want to put in the listing price and terms agreement. So this residential listing contract, exclusive right to sell, rent agreement is between the owner and the listing broker in consideration of listing broker's agreement to find a ready, willing, and able buyer or tenant. Owner gives listing broker the exclusive and irrevocable right to, and then you need to mark here, sell and rent the premises described above. Owner acknowledges that signing more than one exclusive right to sell, rent, or other form of listing contract for the same term could expose the owner to liability for additional compensation. So you need to let your seller know if they want to work with multiple agents, it's not a good idea, and they could be end up owing multiple commissions to multiple brokers. The listing price shall be sale, and you put in the dollar value there. Rent per month, plus in the case of a rental, all applicable leases or rental transaction privileges, taxes, or such other price and terms as are accepted by owner. So line 21, term, this agreement shall commence on this date. So you always got to put a beginning date of when it's going to start, and you need an ending date of when it's going to stop. And shall expire 11:59 Mountain Standard Time on this date. All right, that's the expiration, the start date and expiration date. Upon full execution of a contract for sale or lease of the premises, all rights and obligations of this agreement will automatically extend through the date of the actual closing of the sale or lease agreement. Capacity, owner or any part that owner designates to act on their behalf warrants that they have the legal capacity, full power, and authority to enter into this agreement, deliver marketable title to the premises, and consummate the transaction contemplated hereby. Modification, this agreement may be modified only in writing, signed by the owner and the listing broker. Equal housing opportunity, listing broker and owner shall comply with all federal, state, and local fair housing laws and regulations, including but not limited to non-discrimination based on race, color, religion, sex, handicap, familial status, national origin, sexual orientation, or gender identity. So this has been updated August of 2024. So again, you want to put the owner's initials on the bottom right, right? This is their listing agreement to help you make the MLS listing. Compensation, listing broker compensation is not set by law, nor by any board, association of realtors, multiple listing service, or in any manner other than as fully negotiated between listing broker and owner in this agreement. Should the owner choose to offer compensation to buyer broker or tenant broker, the offered amount is also fully negotiable and agreed upon after discussion with the listing broker. So owner needs to initial there. All funds are to be in United States currency. Line 38, owner agrees to compensate listing broker and other broker, if any, as follows. Line 39, check if applicable. So retainer, owner agrees to pay listing broker a non-refundable retainer fee in the amount of blank within 5 days or blank days of execution of this agreement, which is earned when paid for initial consultation, research, and other services. The fee, you need to mark shall not be credited against the listing broker compensation. Listing broker compensation. So here's where you're going to mark 6%, 3% to the buyer's agent, 3% to the selling agent. In our brokerage, that's what we charge typically. If the listing broker produces a ready, willing, and able buyer or tenant in accordance with this agreement, or if a sale or a rental of the premises is made by owner or through any other broker or otherwise during the term of this agreement, owner agrees to pay the listing broker compensation of this sale, 6%, the full purchase price of the full purchase price or a dollar value. Additional listing broker compensation. So unrepresented buyer. So go ahead and check that. Owner agrees to pay listing broker additional compensation of blank percentage of the full purchase price or blank dollar value if the buyer of the premise is not represented by a buyer broker. Buyer broker, owner authorizes listing broker to communicate an offer of compensation to a prospective buyer broker in the amount of 3% of the full purchase price or again another dollar value. Owner's authorization includes consent for the listing broker to enter into an agreement with the prospective buyer broker to compensate the broker if they represent the buyer of the premises. In such circumstances, owner shall provide the listing broker the funds necessary to pay the agreed upon buyer broker compensation not to exceed the other amount. Owner shall also pay listing broker the offer amount as additional compensation if any agent of listing broker represents the buyer of the premises. Owner acknowledges that buyer broker represents the interest of the buyers and not the interest of the owner. So again, owner acknowledges that buyer broker represents the interest of the buyers and not the interest of the owner in a transaction unless the agent of the listing broker represent both the owner and the buyer under limited representation as described in section 6. Owner also acknowledges that the buyer broker may credit part or all of their compensation to the buyer. Now, if this is a rental, you would put a percentage there. If not, Most times we're going to be doing sales. So if it's a rental, put a percentage there of the gross rental amount as calculated for the entire term of the initial lease, or dollar value upon execution of lease agreement. Additional listing broker compensation. Unrepresented tenant owner agrees to pay listing broker additional compensation of blank of the gross rental amount as calculated for the entire term of the initial lease, or blank if the tenant of the premises is not represented by a tenant broker. Tenant broker, owner authorized listing broker to communicate an offer of compensation to a prospective tenant broker in the amount of this percentage of the gross rental amount as calculated for the entire term of the initial lease, or some dollar value. So again, usually these lines are not going to apply if you're doing a purchase contract. So for example here, line 46 is where you're going to mark that for the purchase contract. Owner authorization includes consent for the listing broker to enter into an agreement with a prospective tenant broker to compensate the broker if they represent the tenant who leases the premises. In such circumstances, owner shall provide listing broker the funds necessary to pay the agreed upon tenant broker compensation, not to exceed the other amount. Owner shall also pay the listing broker the offer amount as additional compensation if any agent of listing broker represents the tenant who leases the premises. Okay, and then get your owner to sign initial there. Owner acknowledges that tenant broker represents the interest of the tenant and not the interest of the owner. In a transaction, unless the agent of listing broker represents both owner and tenant under limited representation as described in section 6, owner also acknowledges that the tenant broker may credit part or all of their compensation to the tenant. Rental renewal or extension. Regardless of whether the agreement has expired, owner agrees to pay listing broker compensation of blank percentage of the gross rental amount, or blank within 5 days of rental renewal or extension. So again, if you're selling a purchase contract, right, you're selling the house, this rental part doesn't apply. Purchase by tenant. If during the terms of any rental of the premises, including any renewals or holdovers, or within days after the rental's termination, any tenant or his heirs, executors, or assigned shall buy the premises from owner, the sale compensation described in section 4 shall be deemed earned and payable to the listing broker. Broker disputes. In the event a dispute arises between listing broker and any other broker regarding payment of compensation, owner shall not revoke or seek to amend compensation previously offered. Any compensation dispute between broker shall be resolved after the close of escrow in accordance with the realtor's dispute resolution